My name is Debbie Douglas, and welcome to our webinar on Bill C-2. I would like to acknowledge that I'm on the land which has been the traditional home of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit for millennia. Today, this meeting place is still the home to many Indigenous people from across Turtle Island. I acknowledge the enduring relationship between Indigenous peoples and this land and honor the agreements made, including Treaty 13. Welcome to this important immigrant and refugee serving sector conversation. We see public policy at the core of what we do as sector umbrellas in the area of services for people new to Canada, as well as a respect for human rights and our international obligations towards refugees and migrants. We have an obligation as a sector to educate ourselves on matters of public policy and to raise any concerns we have with those who make decisions. We acknowledge the efforts of all the sector umbrella organizations across the country in their respective regions and in collective efforts like this webinar. This is a shout out from OCASI to CCR, the Canadian Council for Refugees, our national umbrella, and our sister umbrella organizations across the country. AMSA out of BC, ASA out of Alberta, SEISHA out of Saskatchewan, MANSO out of Manitoba, TCRI out of Quebec, and ARESA out of Atlantic region. Interpreters, I am so sorry that I've just pronounced all of these acronyms. I know how difficult it is for LSQ and ASL. I also want to say a shout out to our sector colleagues in the Yukon, the Northwest Territories, and Nunavut. Thank you for co-sponsoring today's event. It is my great pleasure to introduce and welcome our brilliant moderator, Gauri Sreenivasan, Co-Executive Director of the Canadian Council for Refugees. Gauri has a long and powerful history of leading policy and activism, and you will find these details in her bio. Please take a look in the chat. Gauri, the floor is yours.
Thank you very much, Debbie, for the warm welcome. I'm Gauri Sreenivasan, and I'm coming to you from unceded Algonquin territory in Ottawa. I am honored and thrilled to be moderating the panel with these distinguished speakers and to see all of you from our community coming out to learn more and ideally get energized and activated to help us in the pushback against this important legislation. The plan for the panel today, I'm going to just provide a little bit of opening context, like what has Bill C-2 landed in, kind of where are we now, and then I'm going to ask the panel a few questions to warm us up, ask them to talk about their key concerns and what we do about them, and then there will be a period of Q&A for you, in which you will be putting your questions into the Q&A function in Zoom. And then we'll have a final wrap up with the panelists. It's wonderful to see you all here in such amazing numbers, and CCR is thrilled to be working in partnership with all of our umbrella colleagues across the country. So just thinking about zooming out at the global level first, because Bill C-2 is very much about how Canada is going to be responding to refugees and immigrants and migrants, as well as many other, really all the population in Canada. But at a global level, it's really important for us to keep in mind that we are facing an unprecedented context of forced migration, from war, from genocide, from climate change, and continued persecution and human rights crises. So there is a rising need for the international community to recognize the context that people find themselves in, migration that is very often forced and propelled by factors outside people's control. And we are a country that has actually faced very little of that because we are bounded by 3 oceans and the US on the bottom. But globally, the need for us thinking about the needs of populations on the move has never been higher. Domestically, in the last few years, though, we have, and I know many of you have been feeling this through your own lived experience and through the populations that you support, at least for the past 18 months to 2 years, a consistent scapegoating of immigrants, of international students, and refugees for what really are decades-long policy failures of governments at all levels and lack of investment, which has led to real crises of access to affordable housing, a cost of living crisis, lack of access to healthcare. These are all real problems that many people, especially low-income and racialized people, feel in Canada, but they are crises that migrant and refugee and newcomer communities experience, not crises that they cause. But the fear-mongering has led to a very sharp rise in anti-immigrant sentiment and racism, and that's so much of what we are, a context that we're facing right now. Then we had a federal election with a mandate that a government that derived from a commitment to stand up for Canadian sovereignty and identity with elbows up, so-called, in the face of a very strong trade war from our main economic partner, the US, and literally threats of taking us as the 51st state. But since the election, the posture of the government has been kind of consistent with the context we've seen in the last 2 years, increasingly one to double down on criminalizing migration and fueling anti-immigrant sentiment, cutting the programs, the services, and the protections that are needed. And now tabling a bill that has shocked audiences from all directions, trying to give itself sweeping and over-generous new powers across a number of areas. So Bill C-2, we have seen very strong broad-based concern with it, push back on what we are calling an omnibus bill. Omnibus because it covers so many areas. It amends over a dozen other statutes. And as you will hear from our panelists, it really increases danger for so many in this country on multiple fronts. So there is a lot at stake for those of us working with immigrant and from immigrant, migrant and refugee serving sectors and the organizations. We want to ask ourselves, where is the bill at as we dive into the panel? Kind of at what stage is it at, and how do we understand where it's going in the parliamentary process? Important to remember, it is not law yet. It is a proposed bill. It is coming to only its second reading in Parliament when Parliament resumes on September 15th. So that means the whole House of Commons will have an opportunity to vote on whether the bill will go to committee for study, which it very likely will. It will then go into a committee process, which we anticipate will extend over the course of the fall, given the posture of opposition parties, at least till Christmas. And ultimately, we'll see what happens to it in committee and whether it goes further. There will be a vote that will have to happen early in fall on second reading. So MPs have an opportunity to vote on the bill soon, and then pending that vote, it would go to that committee process. The other thing to remember is that the Liberal caucus is meeting next week. It meets ahead of Parliament returning. All the parties are preparing for the return to Parliament. But we are starting to see already that the public pushback on this bill is creating ripples and schism inside the Liberal caucus. And we know that several MPs will be taking the floor at the Liberal caucus next week and speaking against the bill and having concerns. So we're at a very key moment now where leaders from all parties are sort of taking the temperature about how are people responding to this bill? How are people in my constituency responding to the bill? What is the need that the government has? What do we need as a party? The outcome is definitely uncertain. Where is this community at to date? The sector that most of us represent here on the call, working with refugees, migrants, and documented people, are positioned entirely against the bill. We see nothing but dangers for the populations that we work with. but we have connected with organizations from other sectors, and we are joined by some of them today, with academics, with civil liberties organizations, with groups from the health sector, with groups working on gender equality, and a whole variety of organizations, and we are continuing to outreach. We have a broad tent coalition that has formed, a network that is meeting occasionally, convening other groups. There are public events happening in Quebec later this week. There are plans to highlight C-2 in mobilizations before Parliament comes back. So the civil society organizations writ broadly are connecting on this bill, and our high-level message is we want this bill withdrawn. We want to talk about the bill as a whole, the multiple dangers it causes, and we think that we can stop it. So that's kind of where we're at in the trajectory of this bill. And it brings us to you and to us today to think about what information do you still need? How does this affect your work? And how might you want to get involved? We have resources that we may be dropping now or will be dropping later in the chat, but already CCR, OCASI, and many of the organizations today have encouraged our members to take action. There is a letter that has been launched by Amnesty, by CCR, by the Migrant Rights Network, by many actions where you can write to your MP to encourage them to vote against the bill and to see it stopped. And there are others that are mobilizing in public events, as I was saying. So that's the kind of the context of where we're at today. I want to turn now to the panelists, whom we are excited to welcome. Tamir from the Canadian Civil Liberties Association, Deepa, Mattoo, Executive Director of the Barbra Schlifer Clinic, Lisa Brunner, who is with UBC, but also is a consultant working with AMSA at the British Columbia Umbrella Coalition. All of them are experts in their own right and have both written and spoken about the bill. So I'm going to ask each of them to kick us off with their kind of opening comments. And so my question for each of you, knowing given the background a little bit of where we're at now, to dig in deeper for our audience today, what would you say is really at stake for people in Canada with this bill, and why should those of us working with refugees and newcomers pay attention? Deepa, may I start with you?
Thank you, Gauri, and thank you everyone who's joining us today. So as Gauri mentioned, I am from Barbra Schlifer Commemorative Clinic, and here at the clinic, we work with survivors of gender-based violence. And many of survivors that we work with are newcomers, refugees, or people with precarious status or non-status. So Bill C-2, as we know, it has been framed as a measure to strengthen borders. So one of the first concern that I want to raise for all of us to question is, whose safety is being prioritized, or whose safety are we talking about when we're talking about strengthening borders? From the reading of the bill and the implications that are involved with the bill, I think some stuff that Gauri already mentioned, I want to reiterate that the bill represents, with its changes, a deep erosion of people's rights. One of the biggest challenge for organization like ours, which works with clients in legal setting and provides representation for clients who are working through different processes of legal support that refugees and non-status folks need, we are really concerned about the due process and the timeline change. And that is, of course, a concern that would concern most of us. The stringent timelines and having access to no claim means that you don't have the due process available to you. But some of the concerns that we should also be paying attention to is around privacy and also access to justice. I'm really concerned, and I would want you and invite you to review the section of the bill which speaks to access to information that enforcement can have And I know the first cursory reading makes you feel that, oh, they're talking about telephone companies or they're talking about financial institutions like banks. I think what we should be really deeply concerned about is that there is a provision in this bill which can make them access information from service providers like us. And it can have them give access to, if the bill is passed, it can give them access to information from lawyers even. And I think the lawyers of this country right now should be extremely concerned about what it can do to their client solicitor privilege. The lived reality of survivors we work with is very, very complex, and I'm sure many of you work with similar clients. They cross borders, not necessarily in best of the situations. They are sometimes lack any safe options available to them. They are crossing borders under a lot of coercion, a lot of trauma, which means that the timelines that are being imposed, this bill is completely failing to take account of those realities, which brings me to my second point, which is that the bill has done no analysis of gender-based violence, and which is a commitment that the government had made to us that all the bills, all the policy reforms will have GBA plus analysis attached to it. But unfortunately, this bill has completely failed us on that. I also want to just reiterate the point that Gauri made around the growing criminalization of migration in public discourses. We feel that from the Schlifer Clinic's perspective, survivors are being caught in these situations of criminalization at many fronts. We are seeing criminalization of survivors in migration. We are seeing criminalization of survivors in local enforcement of laws and with child protection and parenting. So this is not another threat. This could be one of the main threats that the communities that we work with, and they will have lack of access to protection. So should we all be concerned? I think yes, we should be deeply concerned. This bill will compromise our ability to serve survivors safely. This bill, if it becomes law, will make us think about our service provision very differently. We will have to think about our own capacities and how we provide services and how we collect data. So the implications are going to be really huge and deep. So I agree with Gauri in terms of where the bill stands and where the timelines are. I think we should all educate ourselves and understand its implication on our own clients and our own communities so that if in October the bill is referred to a committee, we should all be ready to depute. But before that, as Gauri said, we should be talking to our MPs and sharing our concerns with them.
Thank you, Deepa. You've covered a lot of ground, including getting to the what we may do section, but particularly offering reflections from an organization working with survivors of violence. Lisa, let me just turn it to you. What is at stake for people in Canada? And maybe you could offer a particular comment on what it means for people seeking to make a refugee claim.
Sure. Thank you so much for this invitation. It's really an honor to sit alongside people with such deep expertise, including, I think, many of you in the audience. I'm currently joining from Zokoge, also called Montreal, where many First Nations have gathered, and the Gan-Yegahaga Nation have served as custodians of the lands and waters. So I'm going to focus on explaining two key proposed changes and one big picture concern. The first thing that this bill is trying to do is totally rewire Canada's refugee claim system, and it's adding a lot of unnecessary complexity. So the core of the change is that it's restricting access to Canada's Immigration and Refugee Board, or the IRB, where refugee claims are adjudicated by this relatively independent body. And under Bill C-2, certain refugee claimants would instead need to apply for something called a pre-removal risk assessment, or PRA, which is a paper application instead of a hearing. And that application would be sent to Immigration, Refugees, and Citizenship Canada, where civil servants, and perhaps soon aided by some kind of machine learning tool or artificial intelligence, would be adjudicating the claim. And it's important to know that the PRA, this application system, is not a replacement for a refugee claim. It wasn't designed for this purpose. There's no right to appeal other than a judicial review. The approval rates are super low, and logistically, it's just adding a lot of unnecessary complexity into an already complex system and will increase the precarity that a lot of people in our communities already experience. So who are going to be restricted by this change? The first is implementing this very arbitrary one-year ban, and this is going to apply to anyone who has visited Canada more than 1 year ago, starting back to June 2020. So basically, let's say you came to Canada for a vacation in 2021. Conditions have changed in your country. You now want to make a refugee claim in Canada. You cannot. It's important to note that this is stricter than what is used in the United States, which I think says a lot. And it also goes against the basic norms of humanitarian protections and what is recommended by the UNHCR. The second group of people that are going to be restricted and not able to access the IRB are people who cross between ports of entry from the US and make a claim after 14 days. And this is the government's attempt to try to close a so-called loophole that they themselves have created through an agreement with the US. And we know from research that this will not have a deterrent effect, but instead will be very dangerous for refugee claimants. So that's the first bundle of changes. The second change is expanded powers to manage and cancel immigration applications and documents. And so this was originally proposed in the Trudeau government's fall economic statement last year. And it would basically give the government the power to cancel permanent resident visas, permanent resident cards, temporary resident visas, temporary resident permits, travel authorizations, work permits, study permits, when in the public interest. What does that mean? What is the public interest? It's a very vague term that the government would basically have a broad power to decide. But we know that one key desire of the government is to be able to quickly cancel documents that currently would allow people to come to the border to enter Canada. So let's say, you're not a Canadian citizen and your immigration documents suddenly don't mean what they used to, especially if you're outside Canada. Let's say you have a family member who has a visa to come visit you, or maybe you're a work permit holder who goes abroad to visit your family. The government could immediately cancel the ability to re-enter Canada. So this introduces additional instability into an already quite unpredictable immigration system. And you can imagine how much chaos this could create for applicants and families, both inside and outside Canada. And there's typically no provision for individual review or appeal of this kind of a broad order, so it does raise significant due process concerns. The final point that I just want to make, which is a broader point, is that the bill is very broad and very general. So it gives the government new, essentially unchecked powers in an already very discretionary immigration and refugee protection system. A lot of the details would be left to the regulations that would follow. So we can only guess how this government and also future governments might use these new powers. But I think it's really important to remember that once the government has these new powers, it would be very difficult to claw them back. Thanks.
Thanks very much. Tamir, how do you see this bill as basically affecting people in Canada? And how might it particularly affect organizations in this sector?
Yeah, so I just wanted to open by thank you for inviting me to speak before everyone here today. CCLA is deeply concerned with this legislation. I think I think the background to the introduction of this bill has some pretty significant implications for how it's going to be applied. And my focus today is going to be on elaborating on some of the new surveillance powers that are introduced in this bill and how they will be used. But we're also concerned, but I think the background to the introduction to this bill raises some broader concerns around civil liberties, right? So I think we've heard already that the bill's justifications range from a set of let's call them highly imaginative border-related concerns that the United States has been touting publicly, and that the Canadian government seems to be using as a justification for, for adopting, some US style changes to our legal regime. And this is true for the surveillance powers as well as for some of the other changes that are being made. But also, that our government seems willing and is using to justify a more general public safety power grab. So I think with that sort of background and dynamic in place, the specifics of the bill are deeply concerning, and I'm going to go through some of these in particular in more detail. But there's also this broader concern that, this is signaling a more general willingness to erode civil liberties at a broader and more expensive rate. So this and particularly using this these are challenging bilateral relations with the US as a justification for doing it. And I think that that's a direction, that none of us want to see Canada going. So I'm just going to reiterate what my colleagues have said and say that it's important to speak out about this bill and take a strong stance against this bill and continue to do so if it does move into the legislative process, and if it leads to additional kind of changes of this type. Okay, but coming back to the bill itself, and again, my focus is going to be on talking about the surveillance and information sharing elements that this bill would introduce. And these raise a lot of privacy concerns, and particularly given the background to the adoption of this legislation and the increasing sort of willingness of the government to crack down and scapegoat newcomers and migrants that Gauri was talking about in the introduction, you could expect some of these surveillance powers to be used specifically against migrants and refugees. And I'll give some examples of how that might be the case as we move forward. So, and I'm going to focus today on 3 privacy and surveillance related elements of the bill. So 2 of them are new surveillance or information sharing powers. And the third is this is the way that the bill paves the way for the adoption of a number of information sharing agreements with other governments that could have pretty significant implications for migrants in Canada. So the first concerning privacy or surveillance power that I wanted to talk about is this power that will allow a whole range of government officials, ranging from law enforcement to migration and border control officials to security agencies, to basically just demand, public service, any service really, to confirm whether someone is a client of theirs, and the ability to do this is going to be, these demands are going to come without any of the normal safeguards we have around police and security and border control powers. So they won't need to get a court order. They won't need very much justification to make these demands. There's not going to be a lot of oversight. And then in particular, there's going to be a default 1+ year secrecy provision that attaches to these demands, and organizations who receive the demands will only have 5 days to challenge them. So, which is very difficult for any organization that, that is trying to function on a day-to-day basis. So, I mean, this has a lot of specific privacy concerns, and some that are particular to migrants and refugees and newcomers, which I'll get into. But it also really, especially the secrecy provision and the need to respond really quickly without any ability to challenge these requests, is going to also undermine trust between service providers and newcomers and other types of clients. And the types of service entities that this new power will apply to it's basically everything from health providers to banks to any sort of online service, as well as to organizations who serve migrants and refugees, like many of those who are here today. So so it's unfortunate. And some of the ways that we could, potentially anticipate these powers being used, we're seeing, again, as we mentioned, much more willingness and resources being committed to going after overstays, for example, in Canada. So one way that this could be used is just to create a list of people who are suspected of overstaying and send them out to a wide range of service providers to see if any of them are interacting with the person, and basically use it as a way to track down overstays and target them for deportation. This type of use would again be very insidious and problematic from a fairness and migrant rights perspective, as well as from a privacy perspective. But it also has this problematic implication that if this power is used in this way, it's going to drive a wedge between service providers and people in Canada who are worried about interacting with them out of concern that they're going to be, potentially, revealed in this way and subject to these powers. Service providers that don't comply with these demands or don't manage to challenge them within the 5-day restriction limitation period could face very steep criminal sanctions, including fines. So that's pretty serious. Another power that we're concerned about is that this bill is going to authorize immigration officials to share some types of highly sensitive data very widely. And specifically, we're concerned about their ability to share refugee status and changes to gender identity, given that these are very sensitive pieces of information that are usually, protected. The information could be shared with any public, provincial, or municipal entity, including public companies. And then with some very minimal safeguards, it could also be shared with foreign governments by the immigration officials or by any of the companies or entities that receive this information. Now, disclosing refugee status or changes to gender identity to foreign governments can place migrant groups in Canada, as well as their families abroad, in direct harm. So this is something that, given it a broad dispersal like this, the ability to make sure that this information isn't shared with a foreign government that's going to misuse it in this way is really going to be difficult. And we don't think that this bill has the right types of safeguards to prevent that from happening. And then sharing changes in gender identity, within Canada can place trans migrants and newcomers in very severe danger and direct danger. It could expose them to harassment, violence, and it could jeopardize their access to a range of services, including housing, healthcare, or employment, housing or healthcare services and employment. So that's another set of powers that this is concerning, that is raising significant concerns for us. And then more generally, the bill is paving the way for Canada to adopt a host of some information sharing agreements with numerous countries, including the United States, but also some other countries with a relatively poor track record on human rights in general and adherence to the rule of law. And this is a concern because there is a growing trend right now among several countries, including some that are going to be parties to these information sharing agreements, where there's a tendency to misuse these types of information sharing mechanisms to go after recently arrived migrants in Canada and abroad. And we've seen targeting of newly arrived migrants in Canada already. These new information sharing agreements are not going to have the types of safeguards that you would need to prevent that type of misuse. So we're concerned that, again, this bill is paving the way for the adoption of these types of agreements, which is going to intensify what's already a problematic targeting of newcomer communities in Canada by foreign governments. More generally, many of our safeguards around privacy and around cross-border information sharing are very antiquated at this point, and everybody has recognized this, including the government itself. Of course, we're not seeing any attempt to update these safeguards in this bill, so the lack of that update is another kind of contextual factor here that's problematic, because we're adopting a whole bunch of new powers, exposing people to a whole host of new risks, including migrants, but we're not doing really much to safeguard them. So those are kind of our specific concerns. Some of our specific concerns around the surveillance and information sharing powers about this bill. But we're also, again, as I said in my brief introduction, we're also concerned about the broader kind of willingness of this government to use what's an ongoing bilateral kind of tension with our neighbor to the south to erode civil liberties in ways that are deeply concerning. So I encourage you all to, again, learn more about this and speak out about it. Thanks.
Thank you, Tamir and Deepa and Lisa. That was a lot of ground covered, but it really shows all of us in the webinar kind of the multiple fault lines and entry points. There are a lot of ways that if this legislation were to be adopted as it is, kicks up a number of extreme levels of concern for this community in relation to, for example, this whole point that you're speaking to, Tamir, how our organizations could be compelled to confirm or deny that clients are accessing services, questions that are leading to whether or not they should be in line for deportation or not, information being compelled to be handed over that could be shared with foreign governments. That's very sensitive. And the process is changing in ways that have huge implications for refugee claimants and for gender-based violence survivors. So given that, I'm going to ask you one more round of questions, and I'm going to ask you for slightly shorter answers if you're able to. We know this government only has a minority, but they are only missing 4 votes. And we know that the broad-based kind of public environment that's out there now is very strong on scapegoating refugees and immigrants, explaining that tough borders need tough action. How do we approach getting this bill stopped? And I don't mean just technically, we have to get both. I mean, in the context of what you're saying about the issues, and for organizations here who are thinking, what's the frame that I use in talking to the public, or am I talking to MPs? What would your advice be about how organizations can speak to how and why this bill needs to be stopped? What advice would you have for them? I'll just go in a slightly different order than how we went the first time. So Lisa, maybe I'll start with you.
Sure. Thank you. I mean, I want to acknowledge that there are very well-known problems with Canada's immigration and refugee protection system. Backlogs are one example. Decreasing public trust in the system is another, in part linked to those backlogs. And many different organizations and researchers and individuals have proposed innovative, cost-effective solutions to those problems that align with Canadian values. The organizations and researchers were not consulted for this bill, and instead the bill is essentially creating new problems. The IRB may see less refugee claims, but those people in need of protection are not going to disappear. Instead, we're probably going to see backlogs at IRCC, which is currently cutting staff and resources for applications for pre-removal risk assessments. We might see backlogs at the federal court for stays of removal. The Canada Border Services Agency might be overwhelmed with removal orders. And more importantly, I think the number of people in Canada with precarious status is likely to rise. And we know from decades and decades of research what a heavy toll that this can have on individuals and families and the communities at large. So I think one of the key messages we want to convey is that there are ways to fix the system where people are not speaking out against Bill C-2 because they think the immigration system is functioning perfectly. It's because this bill is not the way to do that within the framework of Canadian values and our country's humanitarian responsibilities. I think if I can add one more point, we really have to debunk and pre-bunk misinformation about immigration in its tracks, because there's a lot of it happening right now. We know that fear and anxiety make people more reactive and less critical of misleading claims. And a lot of people are fearful right now, given the multitude of complexities. And we also know that repeated exposure to a falsehood increases our belief in it. And once misinformation is embedded, it's really difficult to debunk that information. So I think as people are discussing this bill and this broader climate that has already been discussed, we really need to think about the 2 narratives that absolutely cannot be normalized. One is that Canada's borders need to be strengthened. It's already extremely difficult for the majority of people around the world to come to Canada. And second, that immigration or refugee systems are somehow a problem, rather than the interests of like the 1% and the corporations that are driving economic inequality, defunding the public housing sector and exploiting workers, as you've already given in your introduction. So I think there are some real concerns and real policy problems, but the problems are not the ones that this bill is presenting, and this is also not the way to fix them.
Thank you, Lisa. The whole thought about our actual world-class immigration and refugee system being part of the solution. How do we encourage it to be part of the solution instead of identifying as a problem makes a lot of sense. Tamir, Lisa's also raising the question of the new inefficiencies and the costs that get produced. So if you're giving advice to this group on how to approach getting the bill stopped, are there other kind of issues or recommendations that you would make about the case that they want to make? Does this bill even solve the problems that the government is proposing as cover that it does?
Yeah, thanks, Gauri. And the answer to that is no, it does not. I would stress, if I was making the point to an MP or some other public official that, this bill is a mistake, I would stress a few things. First, the government is, presenting this as a response to the mandate that they got during the election, but the mandate that this government got during the election was very, very clearly to push back against what many see as a very drastic erosion of civil liberties and respect for migrants and fairness across the border. And instead of following through on that pushback, what we're getting is a bill, basically again a bill that erodes rights of migrants and adopts a number of and civil liberties more broadly. So I think that making that case is helpful and important. More generally, this is being, to the extent that the government is presenting this as, as a way to, appease, I guess, the United States and against the backdrop of the concern, the impending trade war or ongoing trade war, however you want to look at it. I think it's also important to mention that these appeasement efforts are not really working to the extent that any of what's in this bill is actually responsive to demands from the US. The demands just keep coming. We haven't really seen any corresponding alleviation in the cross-border trade threats from the US. So I'm not really sure that it's not an effective strategy on the other hand, nor is it responsive to the mandate that the government got. And then more generally, looking at the bill itself, as Lisa was saying and others were saying, there was no consultation on this bill. So elements of it are going to cause really significant even public safety harms in addition to the privacy and privacy harms that I mentioned before. So there's an element of the bill that I'm not going to go into in a lot of depth, but it basically allows the government to order companies to change the way their services work to facilitate surveillance. And these types of regimes have been shown to create very severe cybersecurity risks that the government has not really thought through in our view. So emphasizing this lack of consultation and real potential for unintended consequences is, I think, also helpful. And just more generally emphasizing that, no justification, this flows from the lack of consultation, but no justification has been made to show that, any of the surveillance powers in this legislation are needed or at all. And many of the powers being introduced here are things that could be addressed through, that more thoughtful and careful use of, policing resources, for example. So anyways, I would emphasize all these as well as the broader kind of, aversion to going down this path of erosion of civil liberties as a response to, what are, to a cross-border dispute that is based on, to a great degree on a lot of manufactured myths about migrants.
I'm going to do a really quick follow-up because I know many people will have seen there's a very strong pushback from privacy and data groups about how this doesn't solve the issues the government is trying to say that it does, and it's inventing problems that it doesn't. But can you just provide a quick comment? I think many people in the sector are thinking that that's where the energy will go, just to try to reform some of the aspects in relation to data sharing and civil liberties, and that will make the bill just palatable enough to sail. How would you talk to the groups here about the risk of narrowing in on one issue versus another, or do you think that's the real concern? So how do you talk about the linkage between the issues versus this possibility that we could just focus on fixing this issue? And then
Thanks for that question, Gauri. So, I mean, I think pulling together a lot of the themes that I just mentioned, I think you could do that in a way that responds to that. So the lack of consultation is evident throughout this bill, and its lack of like careful, thoughtful, tailoring is something that cuts across both the privacy elements and the other elements of this bill. I think from that perspective, this bill requires a sort of a complete rethink. More generally, I think it's important to take a, united stance against this, or the erosion of civil liberties that this bill represents, and that again cuts across both the migrant refugee eroding elements and the sort of the broader kind of the privacy and surveillance elements. We're hoping that we're hoping from a very kind of practical perspective, we're hoping that the bill is kind of considered as a whole when it goes through the parliamentary process, so that we can make these points in a unified way. But I think there is a lot of it's a lot of the same problems really that are coming through for the privacy and surveillance elements of this bill, and the migrant the elements that address other, there's drug control, there's a lot of other stuff in this bill. So I think reinforcing, those, the lack of careful consideration that should have gone to this bill, the need for a very dramatic rethink of the entire package, the potential for unintended consequences that cuts across all elements of the bill. The fact that many of these problems could be addressed better with less intrusive ways that are not, basically replicating a lot of the problematic erosion of civil liberties that we're seeing to the south, and even going further than them in many cases, as Lisa mentioned, and is the case with some of the surveillance bills. I think reinforcing all these joint kind of features that cut across the entire bill might be helpful.
Thank you, Tamir. So I'm going to encourage people to get ready to put their questions in the Q&A, because it's going to be your turn soon, and we have a good solid 20-25 minutes where we're interested to take your questions. Deepa, hearing what Lisa and Tamir have already identified, what other advice from the Schlifer Clinic's perspective would you have for how we can approach getting this bill stopped? What are the main frames, and thinking about the factors that the government hasn't even taken into account? I know you often talked about this government actually has a vision for immigration, but what other ideas do you have for this group about how we should approach framing the need to stop the bill?
So I'll open with saying something that number one, I think, is a sector we all need to come together to believe that we can stop this bill, that it is at a stage where our interventions and our structured approach can create enough voice of opposition to stop it. We need to remember that we have in past successfully reversed legislations and bills which potentially were going to harm the most vulnerable of our communities. And hence the intervention from the Schlifer Clinic about the fact that the communities we are talking about, and we are putting restrictions on having access to a due process, we are talking about people with trauma, people with experience of violence, displacement. Their access to justice and resources is not same as other people. This restriction and the bar on that, if you were in this country since June 2020 and now you can't make a claim, think about how do people survive when they are forcibly displaced and come to the shores of this country for protection. Think about the fact that Canada is signatory to so many international conventions that Canada is required to provide safety and protection to the survivors of gender-based violence. So a few things that I want us to think about as the sector is we are permitted to engage in opposing the bills. I think sometimes we get this fearful about the fact that are we allowed to do in engage in these activities? And I want to encourage all of us to think about that. Engaging in a public policy dialogue and development activity is something which is a very much allowable activity for most of us, especially if it is in your mandate to work with refugees, migrants, non-status, precarious status people. If that is part of your commitment, if that is part of your articles of incorporation, if that is part of your mandate and your strategic plans, please, this is your time to raise your voices and oppose this bill. Engaging public engagement, encouraging public engagement is another thing I want to raise. I want to invite all my colleagues on this call and other spaces who have influence in ethno-specific media, who have influence in pockets of alternate media. Please engage those channels. Please engage your communities, because I think rhetoric that it is something that is going to create an environment that will only harm people who are new to the country or coming to the country, is not necessarily educating people that it's not about someone who's coming new or someone who will arrive like tomorrow. You have to think about someone who has been in the country 5 years. Think about minors who have been in this country for 5 years now, and they are going to be stopped from making a legitimate claim. So the implication is much far wider, and it is going to impose restrictions on your capacity to provide supports and services. So that piece that Tamir was talking about, and I spoke about in the opening, please think about that. How will you protect yourself, and how much complicated your life is going to be, that when you will be now being subpoenaed, or not even a subpoena, it's not even a subpoena because there is no judicial oversight. It's you will be asked for information on the clients that you're serving, and you will be compromising your own policies and your own bylaws. So think about that. So from that perspective, I think participating with your colleagues in all your sector tables, but also companies that you work with, the private sector that you work with, please submit recommendations, and please submit your briefs. If you don't feel comfortable going and deputing in person, please submit your materials to the parliament. This is one bill for where I know we all work on these policy changes, and a lot of us in service delivery work on these things from the side of our desk, but make your side of your desk bigger this time around. That's what I would say. If you had a smaller desk on that side, make that larger desk, because I think all of us, all hands on deck is needed to oppose this bill, because the implications are going to be much far and wide. Thank you.
Okay, I'm looking at the questions in the Q&A. There are a few in the chat. It's not as easy to monitor both spots, so I'll try and watch the chat, but I would encourage you to add them into the Q&A. There were a couple of technical, more specific questions on the refugee determination part that were answered in the chat, but answered in the Q&A. There was one in the chat as well. So if you're wondering what happened to your question, you can look in the answered column. There's a specific question that's pitched broadly. So interested to hear, and Deepa, you were just now starting to speak to this, but there's a question about the role that immigrant serving agencies can undertake for advocacy in the context of being accountable to a funder of IRCC. So are we expecting that there will be instruction given on how to proceed? Oh, I think that's separate. That's more like probably coming from the advocacy groups. I was thinking that was linked. So how would you answer that? Concerns or fears from groups that are supported and funded by IRCC? How do they think about the opportunity for them to do advocacy?
Again, I mean, I always say that something that organizations, and we are all, most of the client-serving organizations are funded by one government or the other government entity, whether it's IRCC or other entities. Your government, and you're assisting your elected officials. You are assisting your MPs. So we need to stop thinking about that there is a binary of that we are opposing them. We are actually supporting them, and we are helping them make the right law that we as Canadians, people who are vulnerable, as refugees, non-status people deserve, which are in parity and in tandem with the international conventions and commitments. So I think there is a challenge when we locate ourselves as that we are in opposition all the time. We can oppose a particular bill, but we are not in opposition. We are supporting them in doing their job well. So I think that really helps in thinking through about how do you frame when you do your submissions. But in terms of also understanding what is an allowable kind of advocacy is really important. So I would ask you to go take this problem to your boardrooms and have these conversations in your boardrooms and look at your commitment of what have you committed in your strategic plans and your articles of incorporation. What is the commitment that you did? If your commitment was that you were going to support refugees and migrants, I think you are within your allowable limit to do advocacy on this issue. If you are, I don't know, if your commitment was to run a shop of some kind, and there was no mention of migrants and refugees, sure, I think you would probably want to think about if I should be doing advocacy on this or not. And you are, again, submitting policy recommendation is very much within the allowable limit, as well as navigating that with your own funder is all about the voice and how do you propose the changes. Your response to the changes is my intervention. I think it's all about not looking at us as them versus us. It's all about looking at we are all wanting it to be a better place for everyone, and how are we supporting you and assisting you.
Thank you, Deepa. Yeah, I'll underscore and agree that with respect to any nonprofit that's also a charity, there are no restrictions on your ability to do public interest advocacy on anything related to your mission. I'll just say that again. There are zero restrictions now on your ability to do public interest advocacy with members of parliament, with the media, in relation to the purpose of your mission. You have to be transparent in reporting it. You have to be willing to say when you have met with members of parliament, but there is no restriction on your ability to do it. I'm just going to throw you, Lisa, one of the specific questions that come up in the chat, because there's a very quick answer to that. How does this bill, if it's adopted, how will it affect refugee claimants that are already before the Immigration and Refugee Board? How could it affect? So not the people that have been here for 1 year and not made their claim yet, but if you already have a claim at the RPD, how would the bill affect?
Mm-hmm. I'm not sure. I don't know. You might be in a better position to answer that question.
It doesn't affect claims that are already inside the RPD, so it won't have any effect on that. There's also a question in the chat about there's been a call for people to where they can appear before a parliamentary committee to submit their brief. How does an organization get information about how and where to do that?
You can monitor the Parliament's website. You can also put a Google alert to yourself to the Parliament's website so that you don't have to spend too much time to be monitoring that website. And I'm sure Gauri and Debbie and Emmy will make sure that once the committee hearings open, if they open in October, they will also keep the sector informed. But anyone who wants to monitor bills in the Parliament, I think the website is very accessible, but you don't want to waste time on going on the website. I would invite you to do a Google alert to yourself.
Yeah, that's great. There was an early question, which was just, what about if the bill is going to pass, focusing on a few critical amendments? And what are the priority amendments that these organizations would propose? I think that's a strategic question that's in a lot of people's minds. Tamir, do you want to respond to that?
Yeah. So, I mean, I think if the bill gets to committee, you know, at that stage, we'll have to definitely put some thought into. We'll have to, you know, we should be prepared for the bill to go to committee despite the strong resistance that it's facing. Again, before answering the question specifically, I do think we should be continuing to take a strong stance against the bill as a whole and emphasizing how there are so many problems with this bill that it really needs a very comprehensive rethink and reintroduction, maybe, if there's specific justified elements of it that could be addressed. But if we do get to committee, I mean, if it does get to committee and we're starting to look at, you know, ways to fix it, I think there will be resources addressing kind of different elements of it. I think particularly the 1 year, I mean, Lisa could talk to this more and Deepa, but the 1 year kind of limitation on access to actual refugee hearings is, I think, a really important one to fix. On the surveillance side, I do think that the powers that I mentioned to demand service providers identify their clients without any safeguards in place are really kind of problematic and should just go away. There's other ways to get this information that police already are able to get it when they need it, as you know, going through the proper process. So this is really just a shortcut for them, and they don't really need it the way that it's framed. There's the very wide information sharing provisions around refugee status and changes to gender identity. I think, again, also there hasn't really been any justification for those, so those could be rolled back pretty significantly. You know, and if there are specific, and there's other ways of addressing whatever legitimate concerns might be motivating that type of information sharing that don't open the floodgates to abuse in the way that these particular powers do. But I think more generally, and there will be briefs, I think, I know my organization and others as well will be, you know, when we get to the committee stage, we'll be drafting briefs with specific amendments, as well as reframing these broader concerns and the broader need for a rethink of this entire package. You know, as we get closer to that stage, I imagine there's going to be some more coordination, and there'll be abilities to share resources and share different perspectives on how to address some of these specific problems. That's helpful.
Just for those of you asking again on the what we do, and we've been dropping some links in the chat, but we'll specifically come back to identifying some of the resource kits that are available and the different actions that we'll take in. I'm just going to continue going through some of the questions because we want it to be as helpful as possible for the people on the call. Maybe just another quick question to you, Tamir, while you were just speaking. There's someone who is asking, how do you identify which are the governments that have information sharing agreements with Canada? So if this bill passes, which government would Canada be sharing information with? And I know there's both, like, it's both a domestic and international answer, but how would you, some person is asking if is there a list, or how would you describe that?
Yeah, so unfortunately, there's no link. We do know that one agreement that's already being negotiated is going to be will lead to a very significant enhanced information sharing with the US. We already share a lot of information with the US, but they want more. So that's a problem given the current climate between the two countries. More broadly, some of the other agreements that we're going to be entering into are we won't even have a say, actually, who we're sharing information with, because anyone who joins the agreement will automatically be obligated to share information with them. And we've already, I mean, we will, in the resource link, there'll be some there's no one link, unfortunately, because of that, but in some of the resources that have been shared, there'll be examples of some of the countries that we anticipate are going to be entering into these broader agreements that we'll be compelled to share information with. Many of them are ones that we've chosen not to enter into information sharing with, so we know that already. But in terms of, there's no upper bound to which governments will will be joining these. And there's also one international treaty that's a bit further down the road, but that's coming, that has every country in the world signed into it. So that will be, if that ends up being one of the ones that we agree, that we sign up to, then that will be at least very simple to know who we're sharing information with, but unfortunately so, and with, again, with very few safeguards. So sorry, that's a bit of a non-answer, but yeah.
I think it means it's unbound, and that's part of the concern. Lisa, there's at least two questions that are quite similar. It's trying to get a little bit more information about the context in which a government could declare something to be in the public interest and therefore be entering this, using this new power if it passes on canceling permits. So what does the bill say about how a government determines if something's in the public interest or not? Can you comment on that?
Yeah, I think that's a really important question. So the wording of the bill is that it gives the government authority to pause the acceptance of new applications, pause or cancel the processing of applications already in the inventory, and cancel, suspend, or change groups of immigration documents. And so the definition of public interest has been described in basically four broad categories. One is risks to immigration or program fairness. The second is safety, security, and health risks to Canada or Canadians. The third is misuse of government-funded programs.
Excuse me, Lisa. I'm sorry to interrupt from the interpreting team. Can you reiterate the four categories, please?
Yes, my apologies. I can also put some of this in the chat afterwards. The first category is risks to immigration or program fairness. The second is safety, security, and health risks to Canada. The third is misuse of government-funded programs. And the fourth is large-scale emergencies and other unpredictable scenarios. Okay, so the reason why I read these out is because these can be interpreted in many ways. It's very vague and gives the government very broad power. They already have a broad power to do these kinds of things, and they have in the past. I think this might signal that they know that there's some challenges potentially to revoking documents or removing permits, so they're kind of wanting to put it into law to ensure that they can keep doing it. There's some examples that have been given in like parliamentary debates, for example, and some discussions about major irregular migration movements, wide-scale fraud or system errors, pandemics, etc. So it's really broad, and it says that it excludes asylum claims, and that also there would be no immediate impact on the legal status of individuals who are already in Canada. So that's what they have said so far. So I think my interpretation is that the intention is trying to clear some of the backlogs. So there are some applications for permanent residency that have really, really big backlogs, and this would allow them to basically say, okay, all this entire application backlog is now canceled. We're starting over fresh. I think that's one strategy that they want to use. Another is probably that there are, people with multiple entry 10-year visas out there, and the government wants to be able to quickly respond to changes in country conditions and prevent people from coming to Canada in order to make a claim. We can also see that, around November, like the day after the US election, the instructions for visa officers were changed to be more restrictive in terms of the visas that are being issued. So visa officers are now supposed to consider the country conditions. I mean, they already did, but there's now giving more explicit instructions to consider that when they're issuing visas, and also encouraging visa officers to consider whether a 10-year multiple entry visa should be the norm. So this is part of a broader attempt by the federal government to make it more difficult to even enter Canada, basically externalizing Canada's borders, and prevent refugee claims to even being made.
Thank you, Lisa. There was also a question in the chat about what is the oversight to ensure that these things in general for the bill are implemented fairly or not fairly. So I'll just tag on to what Lisa has said, that really the only the only oversight over what could be considered a public interest, need or emergency in any of the categories that Lisa identified is cabinet. So a single minister cannot decide on their own that this whole category of permanent resident visa holders has to be canceled, or this category of refugee waiting to be sponsored, their applications will be suspended. But if they have cabinet support, which in the context of the way our parliamentary democracy works is not that hard, because internally they can have disagreements, but then people are often kind of pressured by party allegiance and by the context of how cabinet works to provide support, then that public interest determination could be made. But that is the only kind of safeguard that there is, which is that the cabinet as a whole has to agree, and that is in the bill. An important clarification that was made in the chat, if you have not yet had your hearing before the RPD and you could be caught retroactively by the June deadline, then you could be caught by the 1-year filing. But if your claim has already been heard, then you would not be caught. So those are the two distinctions in the RPD as we're currently reading the bill. There was a question earlier. It's good. It's so great to see that they're all coming through. There was a question about, which I would throw to you, Deepa, which is in relation to how the bill, which is trying to address this question of, people that are crossing at the border, appropriately or inappropriately, which is not a frame that many of us would support. But how do we look at preventing the action of smugglers and criminal groups and people who are falling victim to that kind of extortion and smuggling? So if this bill isn't a good way to answer that, how would you respond to people's concerns about smugglers and criminal gangs and their operation with forced migration?
I think it's a complicated framework that number one, I won't necessarily put smugglers and traffickers into the same bucket, because smugglers could be people willingly wanting to work with at times when they are in the situation of distress and persecution, and they need a way out to get out of the dangerous living conditions that they are living in, and they need to leave. Whereas traffickers are the ones who are illegally trafficking people without their choice. So I would want us to have a nuanced understanding of these concepts and understand them to be very separately dealt with. I think this whole over-criminalization of every activity by just so for the lack of a better way to explain this, I want to highlight for you that when someone has resources, they go to a legitimate, or if it's a stable country, you go to an agent, and that agent has registered travel agency. But when you are in a displacement, war-torn kind of situation, you go to people who are agents but not regulated, and those at times are smugglers. So that's the distinction I want us to make. But how do you create an environment of safety is by creating transparency in your immigration and refugee process, making it really accessible for people, making it really easily available for people to work with international civic agencies which are supporting refugees and people who need to move on the ground. Creating those transparent mechanisms is the way to protect people. How do people protect themselves from being trafficked? By having access to resources and agency on understanding who this person is who could be an exploiter and who is abusive to me, and how do I get help? So I think the reality of that complexity for survivors who are experiencing trauma can also sometimes be really complicated, because you could be married to your abuser, you could be married to your trafficker. And what does that mean when you're in a forced marriage with your own trafficker? That means that this needs to be recognized by the governments here in Canada and abroad where they're moving from. So I don't believe that a legislation like this, which creates a suppression of people's access to justice and access to due process, is a resolution for those problems. That problem of what survivors experience in migration and forced migration has some best practices given to us by UNHCR, given to us by think tanks, which we need to look at. And while I have the virtual mic, I want to also add that when people are thinking about what recommendations or what amendments can they offer, I think one really important thing, and Gauri, I think you were alluding to it, is to ask for independent oversight of our refugee and immigration processes. I think we need an independent body which actually oversees all of this. I know that everyone says, but we have courts where people can file for judicial review. Absolutely. But that process is case by case. We need an overall monitoring body. All of these legislations that have happened in past or being proposed need to be monitored. We actually need to see that, is there a real tangible data that actually shows how many people's visas were approved, which needed to be canceled, or how many visas are canceled, how many people are displaced, how many people are actually admitted, and how is that really impacting Canadians? We don't have an independent monitoring body, and that definitely is one thing that we all should be asking for.
Great, thank you very much. So I'm looking at the time, and I just want to spend a few minutes for us to kind of review the call to action. What are the organizations who have sponsored this webinar asking and encouraging you to do? We know there are more questions and there's more ways that you're looking for information. So I'll try and identify that as one of the key resources I want to talk about. I don't actually have the link handy. Maybe Jen McIntyre, I saw you talking on the chat, so maybe you have this. There is a listserv, a C-2 listserv that has been created, which brings together organizations from many different sectors. I also saw comments in the chat and in the Q&A about how do we reach other sectors beyond those working with refugees and immigrants. And I was explaining at the outset that we have been building this loose network that rejoins health organizations, LGBTQ organizations, civil liberties organizations, legal organizations, yes, refugee and migrant serving organizations. And we have been trying to meet loosely to think about what are the resources we can create and what are the moments of mobilizing. But they've also created a listserv. So if you were to join the listserv, you would get information there for sure, in addition to CCR and OCASI putting out information like when the committee meet. But the listserv would be a very good way for you to stay in touch with resources and events being organized. So I'm going to ask if someone can drop that in the chat if you want to apply as an organization to attend the listserv. The listserv is not for like lots of small questions. It's for sharing information about strategically how we organize, but it's a very good way to receive those updates. The other thing that I wanted to share is that for those of you that are members of provincial umbrella organizations and may not be members of CCR, but all the members of the CCR have now received a sort of a package action kit. We have a resource that identifies in order to support you in reaching out to members of parliament, that helps you unpack why does reaching out to your member of parliament matter? How do you find your member of parliament? It identifies some targeted key, both members of parliament and senators that we predict are the ones that will be likely engaged by the committee process. So we're encouraging you, and this was another question in the chat, to definitely write to your own MP, because in every caucus, we want to see a ripple effect where people are, and members of parliament in all the parties are hearing that people in their communities and their ridings are concerned about it. So we want you to write to the relevant minister. We want you to write to your local MP. But in this CCR kit, we've also identified the targeted MPs for the committee. So that's a resource. How do I approach an MP? What's a good way to have an MP meeting? The kit also includes a basic messaging guide and a backgrounder on C2, and it includes a one-page leave behind. So something you could hand out publicly, leave with your member of parliament, or distribute and use if you are trying to engage your, your neighbor or members of your organization. So if you're a CCR member, you've received this kit already. If you're a member in our networks, but you are not yet a CCR member, we'll come for you later. But we would also be able to share the kit with you, but you would need to write to us at CCR, and we could share the kit with you. And I'll drop an email in the chat shortly of my colleague. We also want to say that OCASI is putting, I don't know if I have that in my notes here, OCASI will also be developing a kit that will be coming to members soon, or they may be sharing the same one. The Canadian Civil Liberties Organization has a resource sheet, and I think we have the link that we will drop in the chat. There's one link, which is kind of an omnibus link. I'm going to drop it again. I've seen Amy drop it several times. I'm just going to call it all resources. This Google Sheet gives you, is a good pathway for you to see where you can sign an action letter. There's, as I had mentioned at the outset, there are some from Amnesty, there are some from CCR, there are some from Migrant Rights Network. It's important for you to remember you don't need to only write once. So this is how democracy works. It works by volume, and it works with us using your voice. So if you send a letter in through the Amnesty platform, the following week you could send a letter in through the CCR platform, and you can share these links. So these are public platforms, places where your neighbors, your family members could send in letters. So a lot of ways that you can write to your MP and ask other people to do it. The resource kit that I talk about to have you actually meet your MP. And then there is a very important public mobilizing moment that will be coming up on September 20th. So that's just after Parliament has reconvened. And as Tamir and others have talked about, we really see an intersecting agenda here where the movements to militarize borders, to crack down on the core services that people need, this kind of austerity approach to government, reducing access to healthcare, to education, and legislation that is very dangerous for our environment and our shared climate. There's a large mobilization for people, for peace and the planet, linking the concerns with the war and genocide overseas, genocide in Palestine, militarization overseas, the militarization of our border, the rollback of climate protection, and the rollbacks on core social services. That is a big mobilization day. It's called Draw the Line. And if you look for events in your neighborhood on the 20th, you can also speak out against Bill C-2 in the context of that mobilization. So yes, send your letters, yes, have the meetings, but let's also try and show up locally in our neighborhoods, in our streets, at these events across the country where we can. I'm just looking to my panelists. Were there any other resource actions that we want to identify? Covered. The last point I'll say, and then I'm going to go to the panelists for their closing one sentence, is somebody asked about other sectors. So that is the last key ask of you. If you have contacts in the health community, in the medical community, in the education community, in housing, you can encourage them to learn about this bill and to get involved, because absolutely we need to grow the collective power across many issues and dimensions in order to show politicians in this country that we are saying no to Bill C-2. So let me give a final word back to my panelists for your last thought for those who have gathered here today. Tamir, I'll start with you, but just one sentence each.
One sentence. Oh boy. Just thanks for taking the time to listen to our concerns on this. Please do make an effort to speak out. This bill really does represent a problematic direction and is going to introduce some real significant civil liberties problems in Canada that we're going to have to deal with for years to come if we don't speak out now. So I would really encourage you all to speak out, and thank you for listening today.
Lisa?
I would say, even if you trust the current administration, the current government, imagine if a different government had this power. Imagine if Polyev had this power. Imagine if a future conservative government had this power. Would you still be comfortable with the government having this power? I think it's a very scary thing that we really need to take seriously.
Deepa?
I think what Tamir said, I will say it in Urdu and I will very quickly do a translation. They say, "Lamhon ne khata ki thi, sadiyon ne saza pai," which means that movements make mistake and centuries pay for it. So Tamir is actually asking us to think it through. Take the action right now, because if this moment is lost, we will be curating it for years to come. And my colleagues and my lawyers, colleagues in the room, I do believe in test case litigation. I do believe in public interest litigation, but I do still believe that there is an independent monitoring body needed for these activities done by our IRCC and CBS. Thank you.
Thank you, Deepa. And my closing note to all of us is we cannot underestimate what public mobilization can do. It feels like the odds are stacked against us. We have legislation, the government's thought it through. I will tell you, they are already stunned and surprised by the level of pushback. They have underestimated the way in which people do not see this as the direction for their country. When we think about how recently we were in a federal election and we asked for Canada to stand up and be ourselves, represent historic commitments to human rights, and to not follow what we see leaders in other countries are doing. This is not what we asked for. Nobody asked for it. And with powers of mobilization across communities, it won't work with a few quiet letters or a few meetings in Ottawa. This is really about mobilization in your communities and with your members of parliament. We can send the signal that this is not the legislation we want, because it's not the country that we want to build together. And with that, I'll turn it back to you, Debbie, for final remarks with a thank you for including me in today's session.
Wow. What a dynamic session. Thank you. Thank you, Gauri, for great moderation. Lisa, Tamir, and Deepa for your thoughtful contributions. Thank you to our audience for the great questions and the conversations in the chat. Everyone who registered for today's conference will receive a follow-up email with all of the links that have been shared. As you know, the webinar has been recorded. It will be available on the OCASI YouTube channel, and we encourage you to check in on ocasi.org from time to time to get any updates about Bill C-2. Please heed what it is that our panelists have said. Get active, speak to your elected officials. Let's continue to make noise and say no to Bill C-2. Stay tuned for more information from all of the various groups who have presented here today. Thank you again to our umbrella colleagues. Let's continue to do our work. Let's continue to remind our member agencies that as a sector who believe in creating a world that is equitable, that we have work to do. We have an obligation to ensure progressive public policy in Canada. Thank you all. Have a great rest of the day and a wonderful weekend.
Thank you, everyone.